Uh-oh, you need more lines. You were being pulled down.
Good afternoon.
Good afternoon, Madam Chair.
Good afternoon, Senate Finance. It is my pleasure to bring the committee together for our first in-person interim briefing on collective bargaining in the states and Maryland. And I will introduce our panelists in just a moment. But I would be remiss if I didn't open this briefing by just saying thank you so much to each of you. This will actually be the last briefing that I have the honor of chairing. And it has been an amazing experience getting to work with each of you. The incredible staff of Senate Finance is here, and they're going to continue to do this amazing work to help us stay together and advance the issues that are going to impact the state in the coming year. And to a person, each of you adds so much value to the work of this committee. And together we did some really important work that I think the state is going to see the impacts of, you know, for the foreseeable years. And I hope that I'm confident that the great work that is being done will continue. Each of you should have received from President Ferguson the announcement naming the new chair of Senate Finance Committee. So let me pause and acknowledge incoming chair as soon as I resign. Not today. My resignation from the Senate is going to be effective on October 31st. And you all know by now that the new chair will be the senator from Anne Arundel County, Pam Beidle. So we will toast her in a special way a little later, but and I just want to just especially again just thank Tammy Kraft, who's just been really just a delight to work with, and I know that she's going to continue to be just the glue that holds the committee together and helps the oil that helps the machines run on time. And we're gonna hear from David in just a minute, but I want to thank David and Patrick and Nathan each for their contributions to what was like a really amazing year for a first-time chair of a standing committee. They did just a wonderful job of helping me and the committee members get up to speed on the work and the various subject matters, those that we inherited and those that were carried on from previous years. So thank you all so much for your work. Great staff. And now with that, because you all know I could go all day, but no, I can't. We did come together today. During the session, we had a number of bills that pertain to collective bargaining in Maryland, and thought it would be helpful for us to get a briefing on the subject. So we've invited Zachary Barnes, who is a policy specialist, employment, labor, and retirement program with the National Conference of State Legislatures. And we'll hear from him first. And then second, we will hear from our committee's own, but also the Department of Legislative Services Principal Analyst David Smolsky will share with us some information on that topic as well. So you can proceed.
Thank you very much, Madam Chair, and thank you members of the Maryland Senate Finance Committee for having me here to speak to you today. As you said, my name is Zach Barnes. I'm a policy specialist with the Employment, Labor, and Retirement Program at NCSL. For anyone who may be a bit unfamiliar with us, we're the bipartisan membership and professional development organization for state legislators and legislative staff in all 50 states and territories. We provide nonpartisan research, testimony, and technical assistance, kind of like this, on just about every topic under the sun to strengthen the legislative institution in the states. Part of my role on the Employment, Labor, and Retirement Program is to identify and track legislation introduced in the states and sort of follow those developments over time. The main areas of policy I cover include collective bargaining, as well as unemployment insurance, occupational licensing, and a variety of other sort of smaller niche issues. I only plan on speaking to you for about 15 to 20 minutes today to hopefully leave time for questions if you have some. But throughout this sort of overview, I'll briefly cover some of the history of public employee collective bargaining, do some level setting with key terms and processes, and then look a little bit more at how other states handle collective bargaining for public employees specifically. So with this sort of outline out of the way, we'll get right into it. Core concepts and tactics that are typically associated with organized labor groups actually predate the United States by a pretty significant margin. Some of the earliest recorded strikes, or what we would now consider to be strikes, first took place in the 1600s, which is pretty neat, I think. This image actually depicts the first assembly of the Virginia House of Burgesses. Polish craftsmen wanted to vote in elections in 1619 and stopped work to protest not having the right to vote in those elections. We actually know this from the records of Captain John Smith, of all people, that this happened, and then eventually the colony gave those workers the right to vote. Trade unions, though, would not really exist as formal permanent organizations until the 1700s, and it would take until the later 1800s for national and international unions to really gain prominence. I know the focus of the hearing today is on public employee collective bargaining, so I offer this as some context for the relative historical recency of collective bargaining for public employees. It wasn't until 1959 that Wisconsin became the first state to authorize collective bargaining for public employees. And in less than a decade, another 21 states would enact some form of collective bargaining authorization for state and local employees. Today, the right for public employees to collectively bargain is explicitly guaranteed in statute in at least 31 states and Washington, D.C. The remaining either leave it to local jurisdictions to determine or do not cover all public employees. In rarer cases, collective bargaining for public employees is expressly prohibited, except for certain occupations, which are usually police and firefighters, excuse me. I'll come back to some of those differences in policy approaches in just a minute. But before I move too far on, I want to briefly touch on the subject of union density, sort of what rate of employees are actually members of a union. Earlier this year, the Congressional Research Service, which is also nonpartisan, released a report analyzing union membership data. It's a fantastic report, and I recommend you read the whole thing if you have the chance. They found that as of 2022, the union density of public sector workers was 33.2%. The union density of non-airline and non-railroad private sector employees was 5.7% by comparison. Over the past 40 years, that density has been pretty steady for public sector unions and has been steadily declining for private sector unions. They produce this excellent graph, which I have here, where you can see the trends over time. And there you can see the airline and railroad workers up at the top there who are significantly more unionized. I would also note, though, that these membership rates are not indicative of how many people are represented by a union. A person can be represented by a union without being a member, and that is something I will come back to later as well. So now that we have an idea of how many people and states are involved in this whole process, I think it would be a good time to sort of go over what people really mean when talking about collective bargaining. There are a million things that we could spend all day discussing, but for right now, I'm really just going to focus on the big ones and in the public sector specifically. The process itself begins with the employees determining that there is some kind of need to negotiate their contracts collectively. And if that is the case, then they organize themselves into some kind of labor organization authorized to negotiate on their behalf. I know that was really wordy, but most states refer to unions either as employee organizations or authorized representatives in their actual statutory language. So I wanted to include that. Once the employees have done that, the union then makes a request or demand to be recognized by the employer as the representative of the employees in their contract negotiations. Employers can voluntarily recognize a union, but that is rarely the case, and most employers decline to actually do so. Assuming they've been declined, the union then petitions the National Labor Relations Board to hold a vote of all the covered employees. This is often called a certification election, in that if they win, the union is then certified to represent the employees, and the employer must then negotiate with the union. Before they negotiate, both sides designate teams of people to represent their interests in their negotiations. These teams can vary by state or municipality for the employer side, and the union negotiators are often selected through a process that is outlined in the union's constitution or its bylaws. Then finally, negotiations can begin. These typically take at least a few rounds of negotiating, but can easily take longer, especially if it is a new union negotiating their first contract. or if there are particularly contentious items up for negotiation. When a contract is being renewed or extended, it's common for many of the provisions to remain the same, except for a few key ones. Those are typically classified by states as mandatory, permissive, or prohibited items of negotiation. With regard to income, wages and hours are usually mandatory topics of bargaining. Employer contributions to health or retirement funds are often permissive. These are also typically cases where merit pay increases may be negotiated as well. On the employee wellness front, there are usually fewer statutory protections. However, common negotiable items that fall into the permissive bucket include vacation and sick time, health insurance, working conditions, and various grievance and arbitration procedures. Although the landscape of what states allow public employees to collectively bargain has remained mostly unchanged over the past few decades, there has been some legislative interest in re-examining what items are considered mandatory or permissible topics of negotiation. Finally, once both teams have reached a tentative agreement, they take it back to their respective constituency groups for their approval to be ratified, for the contract to be ratified. For employees, the union has a ratification meeting where the members of the union itself vote to approve or send back the agreement. And the management usually approves the negotiated contract in one of their governing meetings. This is where I believe most states actually differ from Maryland. And thank goodness David is here to speak about Maryland specifically. Most negotiations are conducted between and approved by covered employees and their employer without too much additional state involvement. And by that, I mean teachers typically negotiate with their school boards, state college and university staff with their board of regents, or police and fire departments with their municipalities directly. But from there, assuming both sides approve the contract, that is the end of the process. If one of them doesn't, they return and go through the whole process again. If it isn't on the slide, but this is where strikes and lockouts typically happen if the two sides just can't come together. Strikes occur when the workers are trying to force management to accept their terms, and lockouts are the reverse and initiated by the management side. Both of these tools are pretty harmful to all parties, so they're used infrequently, and it's a big deal when they're used. Strikes are more common in the private sector than in the public, and even in states with strong labor protections from public employees, the right to strike often comes with some big strings attached. Public safety employees are generally forbidden from striking, and usually certain conditions have to be met for other public employees to strike. Assuming a contract is approved, though, and a question later comes up about the contract, both parties can bargain a memorandum of understanding about that particular item or question. This is especially useful when something unforeseen happens after the contract has been approved, say something changes in the legislature, and both sides want to resolve that matter without having to renegotiate the entire contract. Collective bargaining negotiations are an intense process, and they're almost fractal, in my opinion, where the more you look at it, the more details you find and have to wrap your mind around. And one of those topics that I want to take a closer look at here is dues. Sometimes, I turned my page too soon. Money to pay for the work of the negotiators often comes from membership dues. Sometimes union leadership can receive a stipend depending on what their local or council authorizes, but really much of it goes to contract negotiations because it is labor-intensive work. Dues, their collection methods, and their expenditures have been a hot topic in both state legislatures and in the public discourse. The general trend on this front is to allow dues to be deducted from a public employee's paycheck directly by the employer, so long as the union has obtained that employee's authorization to do so. However, there are still a few states with more specific restrictions in place, and I'll touch on those here. As of this spring, Iowa, West Virginia, and Wisconsin all prohibited dues deduction from employee earnings. Kansas allowed dues to be deducted from employee earnings, but prohibited that money from being used for partisan political activities by the unions. And just this past session, Florida enacted a bill to differentiate between collective bargaining units that represent law enforcement, correctional employees, and firefighters from units that represent other public employees, with the payroll deductions there prohibited for public employees, but allowed for public safety employees as defined in their bill. Otherwise, most states either allow union dues deductions in some form, include them in the scope of negotiations, or simply do not have a statute governing how or when dues may be deducted. This ties in with another topic I believe is of interest to the committee, and that is agency fees and the Janus v. AFSCME court case. In short, an agency fee was the requirement that a public employee still pay a fee to the union despite not being a member of part of it. You remember earlier I said that an employee may be represented by a union without being a member of it. An agency fee or agency shop arrangement, depending on your terminology, is where every employee that is represented by the union must pay a fee for the union to recover the costs of the bargaining and contract administration. In its unanimous decision of Abood v. Detroit versus in its unanimous decision of Abood versus Detroit Board of Education in 1977, the U.S. Supreme Court upheld this as a constitutional practice, provided that the money collected through agency fees do not fund any ideological or political cause. In 2018, the U.S. Supreme Court reversed its decision of Abood with a 5-4 decision of Janus. As a result, the provisions in the labor laws of 22 states were overturned, and unions were required to stop deducting representation fees from non-members' paychecks, despite continuing to represent them in collective bargaining negotiations. Essentially, the court held that the extraction of union fees from non-consenting public sector employees violated the First Amendment, and that the Abood decision failed to properly weigh the principles of free speech. Union membership has remained relatively consistent in the years since, especially in the public sector, as we saw in the graphs I showed earlier. However, unions and some legislatures have taken steps to try to mitigate any potential harm done, most notably in California, New York, and here in Maryland. The California legislature passed AB 119 and SB 112, which both require public employers grant access to their employees by the union in some form. AB 119 imposed a time frame on employers to notify their union that the employer had hired someone new, and required those new hires to meet with union representatives during work hours. SB 112 required those employers to provide the contact information of employees to the union for the union to contact them. In a separate bill, California required unions to maintain authorization from an employee to deduct dues from their paycheck, and they must verify this authorization to their employer. Maryland took similar steps to protect union access to employee contact information and permitted union representatives to attend new employee programs such as orientation and training. New York enacted protections for employee contact information in line with Maryland and California, but they went the extra step of allowing unions to withhold full membership benefits from employees who opted out of being a member. For example, a union may decline to represent a non-member in grievance proceedings, which are typically negotiated by the union. In a similar fashion, Massachusetts, Nevada, Nebraska, and Rhode Island all allow unions to charge non-members for representation in grievance proceedings. I think it's safe to say that the general trend on this front is that more states have taken action to soften the impact of Janus rather than the opposite. I do want to leave some time for questions, so I will close by putting up some additional resources here. It's worth mentioning a recent Gallup poll too that found that public support of unions reached its highest levels since 1965 last year. And this year, 67% of Americans say that they approve of them. Suffice it to say, we don't really see interest in this topic dying down anytime soon. NCSL actually has a database for tracking legislation related to collective bargaining, where we categorize bills based on what aspect of the process they deal with that I sort of outlined here today. We actually have a category directly devoted to public employees specifically, and another one for membership and dues, which I would encourage you to check out at your leisure, to the extent that is a leisurely process, I guess. I don't think all of the bills for 2023 are in there quite yet, but they will be within the next month. We also have a web resource on right to work and are currently finalizing a brief report on that subject as well. I know I just threw a lot of information at you, so if you have any questions, I would be happy to answer them. I also have my contact information up here. So if something strikes you after the fact, or you would like a more personal question, please do not hesitate to ask, and I will send you the information that we have. Thank you again for having me, and I will take any questions that you may have.
Thank you very much for that presentation. I think we'll hear from David and then take the questions at the end, if that's okay, Senator? Okay, very good. You can proceed.
I can proceed. Thank you, Madam Chair. For the record, my name is David Smolsky, and I am staff with the Department of Legislative Services, as well as staff to the Senate Finance Committee. And some of the things that Zach just mentioned, I was going to cover maybe in a little more detail, but generally what he described about collective bargaining, and I forgot Tammy is making me advance the slides myself. So I hit the what? Arrow key, okay. So a lot of the things he talked about is embodied in Maryland collective bargaining at a broad level. Sometimes there's slight differences how Maryland is proceeded, but generally collective bargaining is what you just heard about. Some of the terms I will use, I'll refer occasionally to a bargaining unit, which is basically consists of the employees who are represented by an employee organization, which is basically a union. As Zach mentioned, these folks are elected through a process. And that's what collective bargaining is. Collective bargaining is a process where somebody shows interest, there's an election, and then once the election occurs and an exclusive representative or union is designated, then they negotiate with either an employer or management. I think the terms in this for today's purposes could be used interchangeably. My presentation in front of you in a PowerPoint will consist of 3 parts. It's who has collective bargaining in the state of Maryland, elements of collective bargaining, and collective bargaining legislation past and possibly future. Next. Okay. Okay. To begin with, you can't really start talking about collective bargaining unless you talk about the National Labor Relations Act. This was established in 1935 by Congress, and it formalizes collective bargaining and it protects the worker freedom of association. If you go through the slide, you'll see that it's the federal law that governs the right for employees to organize and bargain with their employer, but it covers private sector employers and employees, not nationwide. Public sector employees are specifically exempt, employers are specifically exempted from this act, and it's left to the state or a local government to enact a law providing collective bargaining rights for whoever they choose to provide collective bargaining rights for. Again, I'd like to make clear that collective bargaining is not mandated. The idea is that for to be entered into freely between employees and employers. Employees have to show interest, they have to elect a representative, and then start bargaining with their employer. In Maryland, there are two basic categories of collective bargaining. Much of collective bargaining is found in the Maryland Code, or the laws that govern Maryland. There are generally 2 types here, and I'll break them into statewide collective bargaining. And then there is a separate category, and these are generally entities that exist in a county that the General Assembly decides to grant collective bargaining rights to. And there are differences on how this occurs, and most of you are aware of this through your time in the General Assembly. In a statewide collective bargaining bill, the committee, it gets assigned to a committee, the committee takes action on it, the committee refers the bill, if it passes the committee, to the full body, and the full body can take action on elements of the bill. The ones that some of the entities that are specific to a jurisdiction, what happens there is the bill comes in, it gets referred to a Senate or House delegation, they work on it, it comes back to the committee. The committee generally gives it local courtesy because the delegations have worked on it. And much of these local bills have been vetted by local governments, local officials, local senators, and local delegates. It gets vetted that way. The committee generally grants it local courtesy. It passes the committee, and then it goes to the floor if it gets that far and passes the floor, again, citing local courtesy. But it's not unusual for some of these local entities to coalesce, and then you end up with statewide collective bargaining, such as with community colleges. So if we go down this slide, you'll see that statewide collective bargaining includes state employees, including higher institutions of higher education employees. This was first established in the late 1990s by an executive order through Governor Glendening, where he, in an executive order, said he would meet and confer with various exclusive representatives. The process was formalized in 1999 with a law, so you could actually really call it collective bargaining and not just meet and confer. And then in 2001, state institutions of higher education employees also got collective bargaining rights, primarily through the same set of laws. Also, there are employees of the Mass Transit Administration have collective bargaining rights. This predates any of the collective bargaining rights for state employees and has something to do with requirements of the Transportation Department and funding for mass transit. So they've had collective bargaining in Maryland for many, many years. There's also collective bargaining for certificated and non-certificated local Board of Education employees. Certificated is generally teachers, and non-certificated is anybody else who's not an administrator in a local education agency. And this is an interesting, this is one of those instances where you took something that was primarily local, particularly for the non-certificated employees. And in 2002, most of the Eastern Shore counties were exempted from participating in bargaining for their non-certificated employees. But in 2002, that exemption was lifted. And so now everybody in the school, all employees in the schools have access to collective bargaining. Another example of something that was done primarily at the county level were community colleges. If the local delegation wanted to expand or add collective bargaining or change collective bargaining for their community college, they would come in and go through that process. But then in 2021, after many years, legislation was enacted that established statewide collective bargaining for all community colleges. But something that is still left to the local jurisdictions or in the counties are deputy sheriffs and local corrections officers. In this case, deputy sheriffs in at least 11 counties have collective bargaining, and most of those counties have also added local corrections officers. There is also collective bargaining for libraries in Howard and Baltimore counties. And then there's a variety of miscellaneous entities located within counties, primarily in Montgomery and Prince George's County, that have collective bargaining and are located in the Maryland Code. This includes the Washington Suburban Sanitation Commission, the Maryland National Park and Planning Commission, and the Montgomery County Housing and Opportunities Commission. Regarding WSSC and the Park and Planning Commission, those are bi-county. So both jurisdictions generally have to agree on any changes or any additions to a collective bargaining for those agencies. That would be Prince George's and Montgomery County. There is also collective bargaining authorized in local jurisdictions codes. I'm not going to talk about that here because most of these jurisdictions have home rule or the ability to pass their own laws, and bargaining would vary by each jurisdiction. But I can say that most of these jurisdictions negotiate with either local employees, police, fire, or EMT, or all three. EMT employees are all three. So that's who has collective bargaining in Maryland. Now we'll talk about some common collective bargaining provisions, and this may be somewhat duplicative of what Jack just mentioned, but I'll try to go into a little more detail here. As you can see, these are all the elements of the collective bargaining process that provides primarily to statewide. Some of these actually will, items will actually apply to some of the deputy sheriffs and community and libraries. But this is what applies generally to statewide collective bargaining, which covers state employees, teachers, public education employees, as well as employees of community colleges. Those are primarily the major statewide groups that have collective bargaining. I did not include employee access on here because we asked Zach to talk about that, but that is also something that applies statewide. Employee access is generally not addressed for deputy sheriffs or the libraries. So first, we have collective bargaining. This is bargaining between management or the employer and employees through an exclusive representative over wages, benefits, and conditions of employment. It's generally broken down into two types of bargaining here in Maryland, economic and non-economic. Economic is obvious, wages and benefits. Non-economic is generally more conditions of employment. It can include salaries, uniforms, and items of that nature, parking, however, anything that can come up here. And non-economic items usually generally apply for the term of agreement, but economic bargaining can come up any given year or every year because of the nature of the fiscal appropriations process, and things change from year to year in the budget. Statewide, collective bargaining is governed in Maryland by a labor relations board. This applies to all statewide bargaining. Many of the, unless they specifically identify an entity like that for the sheriffs or the libraries, that is generally left unsaid who has ultimate jurisdiction over problems with bargaining in those areas. Sometimes they will refer to the Department of Labor to take it to its mediation and conciliation unit to address these matters. There's a state labor relations board that governs all collective bargaining for statewide entities in the state. It's established in law. There are equal numbers of representatives on this board recommended by employees and employers. And then there's usually a tiebreaker, and that would be appointed by the governor. The purpose of the board is to enforce provisions regarding collective bargaining law, as well as resolve disputes from implementation of the agreement and implementation of collective bargaining laws. The Labor Relations Board may designate bargaining units, and we'll get to that in a minute. They oversee elections of exclusive bargaining representatives. We'll get to that in a minute. And they certify the results of an election and designation of an exclusive bargaining representative. Again, we'll talk about that in a minute. But essentially, a labor board, as with the National Labor Relations Board, oversees all aspects of public sector collective bargaining in Maryland. Am I keeping up here? Yes. Next, there's the determination of bargaining units. In Maryland, that's generally codified. So in the Maryland Code for statewide collective bargaining for state institutions of higher education, you have three categories of employees. You have non-exempt and exempt. These are determined by the Federal Fair Labor Standards Act. So non-exempt employees are generally folks paid by the hour, and exempt employees are paid by salary. And there's also a separate bargaining unit amongst the institutions for police officers. For public school employees, it's broken down into certificated and non-certificated employees. Certificated may vary by jurisdiction. Some jurisdictions such as Baltimore and Montgomery, I believe, have added nurses to their certificated group, where they may fall under non-certificated in other jurisdictions. There's also community colleges. They have 4 bargaining units. This was done in 2021. There's bargaining for faculty. There's bargaining units for faculty, part-time faculty, and 2 units of non-exempt employees for each community college in the state. Deputy sheriffs and local corrections officers are self-explanatory, although it can vary by a jurisdiction who is considered a deputy sheriff. Some places it's sergeant, some places lieutenant. It depends on what they agreed to during the negotiation process as the bill is being considered by the local government and the delegations. The labor board in Maryland is charged with designating bargaining units also. However, they haven't really done that because most of the bargaining units for state employees have been set since the late 90s with the executive order. There are currently 9 bargaining units that date back again to the executive order and are based on job type. And these bargaining units include labor and trades, administrative, technical, and clerical, regulatory inspection and licensure, health and human service non-professionals, healthcare professionals, social and human service professionals, engineering, scientific, and administrative professionals, public safety and security, which includes correctional officers, and sworn police officers, which includes state police and all the other folks who are sworn police officers and work for the state. There are also 3 additional specified bargaining units in the law for state employees. That one would be the BWI firefighters, MTA sworn officers. They came in with a separate bill a couple of years ago, and they are not part of the other bargaining unit, as well as a recently established bargaining unit for Maryland School of the Deaf faculty. Okay, so A common provision in collective bargaining, which you heard about, is election and certification of exclusive representatives. Again, and for statewide, it's overseen by a labor board. And it basically begins with at least, and this is common tenets of the National Labor Relations Act, at least 30% of the proposed bargaining unit must sign a petition, show interest for an exclusive representative. Again, this is similar to the NLA, and this 30% can vary, but that's the basic common tenet for collective bargaining. The labor board investigates the petition. This is verifying that the folks who signed a petition are actually members of the bargaining unit. The labor board conducts an election. If a labor organization receives the majority of the votes cast, then they become the exclusive representative. The ballot may have multiple unions on it, depending on how many folks get at least 30% interest, and must include a category for no representation. The labor board certifies the results of the election, and an exclusive representative may be decertified by the labor board under a similar process. There are several items included in that apply to state collective bargaining statewide. A lot of these actually don't apply for the individual counties and folks who are in those counties. You have employee and management rights. They can be summarized simply as employees have the right to freely organize, and management has the right to run the agency and manage its employees consistent with its mission. There are also unfair labor practices. This is from the NLR, the National Labor Relations Act, and it again can be summarized as there may be no interference from management with collective bargaining, and for exclusive representatives, there may be no coercion of employees to participate. As Zach mentioned, there are strikes and lockouts. Strikes in Maryland for public employees in the Maryland Code and lockouts are prohibited. There's no, I'm not aware of anywhere in the Maryland Code actually where a strike is authorized. So and statewide, strikes and lockouts are prohibited. Bargaining timeframes. Bargaining has to be concluded generally for a process that fits in with the development of the budget for the next fiscal year. For state employees, bargaining should be completed by January 1st. All it says in the education article for public education employees is it must be timely, but the idea is the same. Bargaining should be included in time for the dollars to go into a budget request to be acted on by a legislative body. If there is no agreement, then you go to impasse and dispute resolution. Statewide, there is requirements for impasse and dispute resolution, and often for the deputy sheriffs and the libraries are also some provisions for impasse and dispute resolution. I'll focus on statewide because that's where most of you have input on these processes. Impasse and dispute resolution is basically three parts. You initiate the process. We can't come to an agreement. Somebody declares impasse. There's the appointment of a mediator and an arbitrator. Generally, the practice is you get a list, and each side selects from the list until you come up with somebody you want to do it. And then generally somebody has to pay for this process, and it usually is equally shared by the exclusive representative and the management. The first informal step is often mediation. The parties, which would include the employee, the exclusive representative and management, must try to come to some sort of agreement informally. In some cases, it may be more formal, such as with the public education employees. But the idea is to get the parties to talk before they have to go to some more formal process. For state employees, the next step, or for executive branch employees and community colleges, the next step would be fact finding, which is essentially each side formally presents facts for their positions, and then those facts are delivered to somebody, and that's where that ends. I'm greatly simplifying the dispute resolution process. In some cases, it can take pages of law to cover, or in some cases, it can only take a couple sentences. But the bottom line is there are three types of dispute resolution: mediation, fact finding, and then the final one, which is arbitration. MTA employees have arbitration, and the public school employees have a form of arbitration. This is where a third party collects the information and makes a determination. And this determination is often what has to happen between the executive and what has to be put into the budget by the executive. However, all the decisions in Maryland law are subject to an appropriation or the availability of funds. So even though there is binding arbitration, I think the only folks who have actually real binding arbitration are the MTA employees. But it still has to fit in, there has to be money appropriated to do this. And I don't think the state is tied even with the MTA, but I can follow up on that. But regarding the public school employees, they have binding arbitration, which will be done by the State Labor Relations Board. However, it's subject to the availability of funds and appropriations process. If the parties agree, then they come up with a memorandum of understanding, which is a contract, essentially a contract between management and labor on how to proceed through the term of the collective bargaining agreement. It includes the terms and conditions agreed to by the parties. An MOU's term is generally 3 years, but may continue longer under state law if no new agreement is reached. An MOU is ratified by the members of the bargaining unit and the chief executive, and it may allow for annual reopening to negotiate economic terms. So that's a summary of collective bargaining in Maryland. The next part is going to deal with what has happened regarding collective bargaining legislation. The chair wanted you all to know what you've done in the past and what you may be seeing in the future based on what you saw this past year. So in 2021, a major piece of collective bargaining legislation, as I mentioned earlier, was taking community colleges statewide. The significant parts of this was you established additional bargaining units for faculty and non-faculty. And the bargaining was phased in over time. The larger colleges had to have bargaining in place by 2022, and the smaller colleges have to have bargaining start this fall. So right about now, the smaller community colleges should be bargaining or starting to bargain, which means those that didn't have collective bargaining should, if they have the appropriate interest, then they, and they have an election and they have a selected bargaining representative, they should be bargaining by now. And I want to say, I meant to say this earlier, that collective bargaining is not mandatory on anybody. You have to have interest by the employees to proceed. So even though you're saying you have a collective bargaining law, again, certain steps in the process have to take place. There has to be an election, there has to be interest by the employees, or else there is no bargaining. Another major piece of legislation that was passed in 2021 concerns state employees, collective bargaining, applicability, bargaining processes, and memorandums of understanding. This provides mostly to institutions of higher education. Under the law that was passed in 2021, bargaining had to be done at the institution level. So there is as many different institutions there are. That's how bargaining was done. This was centralized, so there is bargaining now with the chancellor over wages and benefits. However, there are items specified in the law that still allows for bargaining amongst the individual institutions and the presidents of the institutions. In 2022, a major piece of legislation that passed concerned the Office of the Public Defender. The first step of this bill actually provided, it removed the attorneys in the public defender's office from at-will status. Once they were removed from at-will status, they'd be assigned to a bargaining unit, and they are now able to participate in collective bargaining. And in this past session, you passed, and it was the Public Employee Relations Act was enacted. This combined 3 existing boards. There was a separate board for state employees, institutions of higher education, and the public school employees. It combined all 3 boards into one. They all shared the same staff, so that there was no changes there. But all 3 boards are combined into one board, and it's the Employee Relations Board. A lot of the powers that existed across the state for each of those groups I mentioned were combined, and now you have the same election procedures for the big 3, as well as employee info, share info access, management and employee rights, and unfair labor practices. What do you think you'll be seeing next year, next session? A lot of this is based on what you saw this session. Last year, there was a bill in to provide collective bargaining rights for faculty, part-time faculty, and graduate assistants in the University System of Maryland. That's pretty straightforward. I don't have to go into detail of who these folks are. There is also the Arbitration Reform for State Employees Act of 2023. This was assigned to the Budget and Tax Committee. The Finance Committee was second on this. That bill did three things. It had a constitutional amendment in there that would require that any agreed to funds from the collective bargaining process constitutionally would have to be included in the budget. It also allowed for the use of an arbitrator for the implementation of the MOU, as well as the same arbitrator during the bargaining, and would come up with binding results. Anything that, and the law also had a provision that the Department of Budget and Management would put any monies in there into the budget, as well as the changes to the Constitution. There was another bill that required collective bargaining for supervisory and managerial employees, provided they don't have any direction over the agency's direct goals. Currently, bargaining for these folks are prohibited. And then there's a final bill that's been back year after year. This concerns class size for certificated employees. Back in the early 2000s, there was significant changes to the laws governing collective bargaining for public school employees. One was the creation of a permissive category of bargaining, but there were also made clear that there could be no negotiations over class size as well as school calendar. So for the past several years, legislation has been introduced, and you probably will be seeing that again, that would require that class size be made a permissive category of bargaining. There are probably other bills that you'll be seeing that I can't anticipate what's coming because I don't know. And there's some other bills that have come in the past that I don't know how you may see again. It's hard to say what they are, but that concludes my presentation, and we would both be glad to answer any questions you may have, provided you ask them all of Zach. No.
Thank you very much. Well done. We'll start with Senator Kramer has a question.
Thank you, Madam Chair, and I just want to say that I appreciate all the information that both of you gentlemen presented to the committee. Good, thorough discussion about this important subject matter. Madam Chair, I had the opportunity to meet Zach last week at an NCSL seminar on jobs. And he gave a presentation where he did an exceptional job there. I knew he would again today, and he also was able to give me insights on today's subject matter while I was there. So I want to say thanks to Zach. And of course, there was never any doubt that David Smolsky would do an incredible job. The couple of things I just wanted to talk about, and I believe the committee is clear on it when we were discussing the University of Maryland system, that academic staff do not have collective bargaining rights.
They do not have collective bargaining rights.
Okay, and I would, I guess, emphasize the fact that because employees in state agencies do not have the right to strike, would it not be factual that binding arbitration is perhaps the only way that public employees have an opportunity to have their collective bargaining will respected? Because at this point, and share with me if I'm wrong, David, if, for instance, the University of Maryland system says no thanks, what happens? The employees can't strike. It goes to, at some point, and you went down this list, you know, there's a mediator and they're trying to work through it. Now it goes to an arbitrator, and let's say the arbitrator finds in favor of the bargaining unit for the university system employees. Without binding arbitration, can what are their rights? In other words, can the university system just simply say no thanks?
They can say no thanks. However, I don't think anybody's operating without an agreement right now. So if they had an agreement before, that agreement would carry, and you pass legislation specifying that in circumstances where where they could not come to an agreement without some sort of arbitration. Binding arbitration is a policy call for you all. Initially, when collective bargaining was passed in 1999, it was meet and confer. 10 years ago or so, later you established fact finding, which is a stronger version of dispute resolution where the facts are laid out there. The General Assembly is supposed to get a copy of these facts as well when they're done. And there is some pressure involved with fact finding, but again, that's as far as you can go for state employees. There's no arbitrator coming in, weighing the facts or weighing what facts are presented and coming with their own decision. Again, that's a policy call for you on how to proceed. I can't make any comments on otherwise regarding binding arbitration, since that's what you have to decide to do. Right now it's fact finding.
Okay, I'm sorry. I thought you were finished. So then, for instance, again, with the University of Maryland system, if they do not honor the will of an arbitrator, then it just falls back on whatever existing contracts were in place prior to negotiations over a new contract.
They would operate under the existing contract. Again, there's no arbitrator for the University of Maryland because they are also limited to fact finding. The only folks who have I call it binding up to a point, are the teachers and the non-certificated employees, and that goes to the board. And the board makes a determination that they're supposed to agree to. However, it's everything in Maryland is still subject to the availability of funds.
Sure.
So there's a fiscal relationship between the schools and the local governments, and if that money isn't there, then they have to go back and start negotiations again to come up with something that fits in with the framework that they're allotted.
So if we had binding arbitration, and I agree, it does not exist at this point, it would still be subject to the legislature's ability to appropriate whatever funds might be associated with the outcome of that binding arbitration. That's correct?
It depends on how the bill is structured, but yes, if it was just plain old, it was just binding arbitration instead of fact finding, it would still be subject to the appropriations process.
Thank you. And I appreciate that. And Madam Chair, I would like to just point out for the committee that this committee and the Maryland General Assembly passed a bill a couple of years ago requiring that the University of Maryland system, as all other state agencies do, negotiate on behalf of the entire system with whatever the appointed bargaining unit is. And that was passed by this legislature, and I will share with you it over the past year, it should have been taking effect. I have heard from both the university system, their side, I've heard from the bargaining unit side that there's a disagreement as to how the statute's to be interpreted, and the university system seems to have come up with its own interpretation. And I made the conscious decision to sit in on one of the negotiating meetings last month, and I do have the impression that we have an agency that is not honoring the will of the legislature. And then 2 weeks later, one of my House colleagues also sat in on the negotiations. Now, everybody knew I was there when I went in and sat down. However, evidently, the university system was not aware that my House colleague was there, our House colleague. And my understanding is that the university system was there discussing the failures of the Maryland General Assembly in how they prepared the legislation and how it is to be interpreted. So I think knowing we have a state institution that is not respecting the will of the legislature, we may, in addition to those things that we saw that Mr. Smolsky pointed out, we may have to take a look at refining that legislation to ensure that the law as passed by the General Assembly and its will is respected by all state agencies and institutions. So with that, thank you, Madam Chair. And just an observation, by the way, I note our colleagues who are here and those who are not.
Thank you,
And
Senator.
there does seem to be a pattern
Thank
to
you,
those who are
Senator.
missing, Madam Chair.
Thank you, Senator.
Just-
And let me just say, as it pertains to your final comments, having not been at that meeting, I certainly would not want to interpret things that neither you nor I were there to observe, and no members of this committee, but certainly every session, those who are here have an opportunity to propose legislative solutions to problems that arise. We're going to go to Senator Lamb and then Senator Hayes.
Thank you, Madam Chair. And this question, I guess, could be for either Mr. Smolsky or Mr. Barnes. We're just paging through this memo from AFSCME, and it looks as though on page 2, most states allow for some type of binding interest arbitration. Is that correct? We're in the minority of states when it comes to that.
I would say that it's safe to say, I guess, that you're in the minority when it comes to that. I'm sorry, I don't have the memo personally, but most states do allow for either arbitration or for some sort of additional fact finding, I guess.
Okay. And I think just in looking back at our legislative record, there have been, Mr. Smolsky can probably answer and verify this, that there have been prior bills that have been introduced to allow for binding arbitration, obviously. Right?
Yes, one of the ones I mentioned was that you'll probably be seeing some version of, again, this year would be the arbitration reform. I think it's called or it has been called the Arbitration Reform for State Employees Act of 2023. That and there's been efforts before that to add binding arbitration. This bill did 3 things. It again, it would require the Constitution to be amended, so there was a constitutional amendment attached to it that would put the results of the results of an arbitrator into the Constitution. So would Constitution require the budget to include the relevant information specified in the bill. And also it would require the hiring of arbitrator to basically monitor all the entire collective bargaining process, including the implementation of the MOU. And then finally, this arbitrator would also participate in bargaining discussions. And if they go to impasse, it would be binding arbitration. It would result in binding arbitration. But there have been bills going back probably since when collective bargaining was implemented that in some fashion tried to get binding arbitration in there.
And I think one of the other bills that wasn't on here that probably will be likely to see is a bill for public library employees and
Yeah, I should have put that in there. I don't know how I left that one out there.
I think
So I did, I think I had it in there, didn't I? Yeah, education, public libraries, I forgot to
Oh,
mention
okay.
that one. That was I sort of just glossed by that one. But there was a bill in this past session to expand collective bargaining to all the libraries, similar to what you did with community colleges. So you would put them, they're established in the code. And each county has, I think each county has a library. And you would provide that they would all have collective bargaining rights, similar to what you did with the community colleges. I think in this case, there'd be only one bargaining unit, would be the folks who work for the library. I don't think there were various amendments floating around as the bill was moving. I didn't see much of them. I just know the bill, there was the 2 major bills, and I think yes, that most likely will be back again this year.
Okay. And this could be for either of you, but in skimming through some of the materials, it looks like some states have begun to provide labor protections for private sector employees that are left out of federal protections. And, I guess the question would be, what protections exist in Maryland for federally excluded private sector workers?
Federally excluded private sector workers. I think you're talking about agricultural employees. Primarily, I think the agricultural employees are excluded from the National Labor Relations Act. I think that's the largest group I saw when I looked at that. So there might be something to allow them to have collective bargaining rights. But I don't, I think you would have to, I don't know how they're going to draft the bill or how it's going to take, but if they're excluded from the National Labor Relations Act, it would have to be somehow, you'd have to provide collective bargaining at the state level for these folks.
So I think in some of the materials that one of
Zach
the
might have
unions
more
provided,
information about.
they had mentioned childcare providers, like childcare workers in Alaska, for example, were.
You have a law in the books for childcare workers, as well as for humans or personal care workers. They got collective bargaining rights a while ago, but then there was another Supreme Court decision that said something that I forget what that decision was, that basically the state is no longer pursuing collective bargaining for these workers, but there is language in the code that hasn't been repealed concerning childcare workers, but they're not pursuing it because of, I think it has to do with collecting fees. Again, it has to do with dues collection. You can't force folks to pay dues, regardless of whether they're a member of the union or not. I think that's what that decision was. That was the some would call it the precursor to the Janus decision.
If I can contribute also to that, on the private sector side, there are a couple industries where we're seeing more legislation to either extend or modify collective bargaining rights to two industries in particular. One would be sort of employees or some cases like private contractors in the like so-called gig economy. So more clearly defining what an employee is, and then by extension, give them collective bargaining rights. We've seen a lot of legislation on, and then also employees in the sort of now growing state to state cannabis industry.
Okay. And then this is a question, I guess probably mostly for Mr. Barnes, and maybe you can follow up with this information later, because I don't know if you have it offhand. I think one of your charts here shows that most of the nation has public sector bargaining, but it doesn't show what types of public sector jobs are either included or excluded.
Yes.
And if you can follow up with information about whether you have data on what public sector jobs from each state are excluded compared to Maryland.
Yes, I'd be happy to follow up with that information. I chose to sort of exclude that for the time being, just because you can get really into the weeds on how specific states classify public employees. I think it is Texas where public employee collective bargaining is explicitly prohibited. And then from that chapter, the definition of public employee does not apply to police officers and firefighters. So there is some very creative sort of statutory mechanisms that states use for those exclusions. But I'd be happy to follow up with a more state to state level analysis of what those are. And I can send that either to you or to the committee as a whole.
Yeah, you're welcome to share with everyone. And then last piece, and you may need to research this as well. You know, I think it came up during the presentation that our teachers unions are looking to be able to bargain over classroom size. And if you could provide us some information comparing to other states, how many other states limit teachers unions from bargaining over classroom size? And if any state has tried to allow teachers to negotiate for pay bonuses based on classroom size. You follow up with that?
Yes, I will. I'm happy to follow up with that. I definitely don't have that one off the top of my head. Thank you.
Okay, thank you.
Thank you, Senator. We'll go to Senator Hayes.
Thank you, Madam Chair, and thank you guys for the presentation. Once upon a time in a former life, I had an opportunity to sit across the table and represent the mayor and city council and bargaining units of the city. And I believe at that time, Baltimore City Fire Department were the only ones with what is it?
Collective bargaining.
Collective bargaining, but not collective bargaining, but binding arbitration.
Okay.
I'm sorry. Baltimore City Fire Department was the only organization in city government at the time with binding arbitration. What was stated in the material is that the limitation is on the appropriation. The appropriation exclusive to the amount of appropriation allotted for that department or salaries, or in the state, are we looking at the global budget of the state? So in other words, is the limitation based off of how much is directly appropriated in cases of, say, salaries? Is it strictly the appropriation that's appropriated through salaries? Or could it bleed into other parts of the state? But what appropriation are you?
I would say it's the appropriation for, employee costs, salaries or whatever. I don't think it would be limited to the overall growth of the budget or the availability of funds. I think it has to be, when you come to an agreement, you agree, most of the agreements concern, cost of living increases or merit increases, at least at the state level. And that, so the state agrees to put in so much money in the budget for the COLA. And if they don't, then, or the General Assembly cuts it, then that's the end of that. So no, I think it's limited to the line item for that particular item that they've been bargaining over.
So bargaining unit couldn't argue the fact that the state has funding, maybe the state hasn't appropriated in salaries, but they can look at other places to support the salary increase that is a result of any binding arbitration.
Well, I don't doubt that comes up. You're funding this, you're funding that. Why can't you fund
Right.
COLA? I'm sure that comes up in the discussions. But in terms of when I mean subject to the appropriations, what is appropriated for salaries at that point, or what they've agreed to include in the budget for that point for salaries, not so much employment incentives through the Department of Commerce or something like that. That would not relate to that. It would, I think, be limited to the line item for that particular item.
Gotcha. And binding arbitration, the limitations around economics is obviously, restricted per appropriation. What are the restrictions around non-economic issues?
No, I don't think there's no restrictions unless they're prohibited by law to discuss anything. They can bring up anything. Again, it's what they can come to an agreement with. If money is involved, then you would think that if they agree to, buy nicer uniforms or more uniforms, that's my classic example, that everything ultimately has an economic effect, but some are more direct than others. So if they agree that, you can get a better, upgraded uniforms or something like that, I don't see why that would be an issue. But again, everything ultimately is subject to an appropriation, at least for state, for the state. So, but some are more direct than others.
And thank you, Madam Chair. Last question. So in the case, like Senator Lamb mentioned, class sizes, is that considered economic or non-economic?
Class size is a policy call that the education, that they've been, that they wrote, there's in the early 2000s, there was more restrictions on what could and could not be bargained, for public school employees. After 2002 or however that worked out, they created a permissive category of bargaining. So there's three categories. Actually, education is more similar to what Zach was talking about. You have what is permitted, what is permissive, which means both sides have to agree, and then what is prohibited. And so the remaining two items that were prohibited were class size and school calendar. That's something that the school boards feel strongly about, and they feel they should have the right to determine class size. It's certainly economic because the more kids you have in the class, but it's something that they feel strongly about, and they think they should have the right to determine that. Well, the unions are saying that it's only permissive. We're not mandating it. Their bills have always made it one of the permissive. So both sides have to agree. But that's again, that's where they've come down on this. And as the General Assembly, it's your call where to go with that.
Thank you, Madam Chair.
Thank you, Senator. Senator Ellis.
Yeah, thank you, Madam Chair. And thank you, gentlemen, for the benefit of your knowledge. So my question is about dual employer status. So let me tell you the context of that question. So in my county, Charles County, we have contract school bus drivers, and they're contracted by the county local school board to pick up the children, take them to school, and big dispute with nationwide school bus drivers issue. Charles County has participated in that, and we're working towards resolving that situation. And like my colleague from Montgomery County, I had the benefit of sitting through their negotiations this summer with the Charles County Board of Education and school bus drivers. And so the school bus drivers they work for the school bus company who are contractors for the school system. Now, the school system determined the hours and the pay and the benefits, but all those are administered by the bus companies, independent bus companies. We have probably 22 of them in the county. And so during this entire collective bargaining work group imposed on them by legislation we passed here this past session, the issue of dual employer status came up as far as, these school bus drivers, they're employed by the school bus companies, independent companies, but their conditions of employment are set by the school board. Yeah. So could I pick your brain on the status of dual employers in Maryland law or just NLRB?
I remember that bill. It didn't come to this committee. It's one of those issues that's considered a local bill, and I know your delegations apparently have been working on this. Did the bill pass?
Yes, it did.
Okay. And now the issue is how to implement it.
Correct.
The employees, if I recall correctly, the employees work for the contractor. So, but they're directed by the school board. So I can't remember actually how that bill evolved because I know there were amendments, but I think it's something they're going to have to work out. And maybe you might have to talk to an attorney general or local counsel about who are these folks employees of. It's somewhat analogous, but not completely to the folks up in Baltimore City who work for what was the gallery? Walters, not completely, but that was a different matter. But again, it's who's the actual employer in these circumstances. I would probably approach counsel, get something from the attorney general or whoever counsel is in Charles County or for their school. I would ask the attorney general since it's a state law.
Okay. All right. Thank you.
Thank you, Senator. Are there any additional questions from the committee? Seeing none, thank you very much for your presentations and your responses to members. Senator Kramer.
No, my comments are not related to the subject matter at the moment, so I thank you, Madam Chair.
Okay, again, thank you very much for your presentation, and members, as was pointed out in the presentation, this is a topic that we heard several pieces of legislation last session. This was not a bill hearing and was not meant to be an exhaustive conversation on the subject. It really was meant to provide baseline information on collective bargaining to the committee and provide some presentations on that topic. So thank you. Hope you enjoy your time in Annapolis. You too, David. Thank you very much. Okay, thank you. Senator Kramer.
Madam Chair, I just wanted to take a moment to say thank you for your time and service here in the legislature. I'm just going to ask, I know offhand Senator Beidel and I served with you in the House. Did any of our other colleagues here serve with the chair? So we had the opportunity to serve with you in the House, here in the Senate. And it has always been an absolute pleasure to work with you. I wish you the very, very best in whatever the future brings. And I very much appreciated your short time as chair of this committee, but I was very, very comfortable with you chairing the committee, and I just wanted to say thank you for that. I know the rest of my colleagues share that same thought, and I also just want to say I look forward. Senator Beidel and I came in together, and I also always enjoyed working with her in the House and have also enjoyed working with her on this committee. So I look forward to her taking the helm and wish you the both the very, very best.
Thank you very much. Senator Vital,
So first,
Madam Chair.
thank you, Madam Chair. Thank you first for your service to us and congratulations, Joe. I'm very excited for you and we're going to continue to work with you. I know that we will. I feel like I've just got such big shoes to fill. Your year here was just really changed the committee, I think. And so I'm a little apprehensive that I'm following in the shoes of someone who's done such a terrific job. And Senator Kramer, thanks for your comments. And I invite all of you to keep me straight. Let me know if I'm doing right or doing wrong. And we'll look forward to really working with all of you, but mostly not to steal any thunder from you, Madam Chair. Thank you.
Thank you. Well, let me just say again, folks, most of you know, I filed my first certificate of candidacy running for office in October of 1993. And so while my time with this committee has been short, I tell you, when President Ferguson gave me the honor of serving as chair of this committee, I could not have been more thrilled and to work alongside him to handpick the A team. This committee has been just phenomenal to work with. And Senator Kramer, you're right. I came in that race in 1994 was not a success, but I did get elected to the House in 1998 and started my service there. And having watched so much bright talent, come into the chambers has been, it's just been amazing to work with the members of the House and Senate. And this committee in particular, I will always hold you guys near and dear and be in touch regularly. You're not going to get rid of me. I am not going far, but even to those who participate as stakeholders in the work that we do, I know each of you take the work that we do so very seriously. And while some of our constituents champion individual issues, this committee has a broad range of topics that you, Madam Chair, will lead this great committee through in the coming years. I'm going to say years, Senator Kramer, since you started with that, but certainly want to just encourage each of you all to keep doing the great work that you're doing. You're listening to the people that you represent, and this is representative government at its best. So thank you all so much. And to the staff, wish you all well. I'll be hanging out with you guys too. Meeting adjourned.